Honorable Chairman, ladies and gentlemen, my subject is a little limitless. Pharma patents in India. I'll try to limit it as far as I can. Patents, as we know, involve and revolve around the whole concept of invention. That is a new product or process capable of industrial application and not obvious to a person skilled in the art. In other words, not in the public domain. Now herein lies a very charming story of what is obvious and what is not obvious, which was told to us when we were studying our law abroad. And the story is simple. There was this machine which didn't work. So they got this top man in the field. And he just looked around and then knocked a particular element in the machine with a little hammer. And the machine worked. And he sent a bill of $1 million. It was paid. Again the same problem. Again he comes and does the same thing. So they asked, what is this? What is this that you know and we don't? And how do you bill it? He said, look, $1 is for the hammer. $999,000 is where to apply the hammer. Now, that is the issue in patent. You have to know where to apply that incremental improvement which will give you a new product capable of industrial application and not obvious to all others who have the hammer. Now in India, there was a very big issue. The issue was, on the one hand, we all know that invention is expensive in pharma industry. The invention cost of a drug which can be patented or would be patented starts from 800 million, that's the bare bones price, and goes on to several $billion. Obviously, the life is limited, 20 years. So you would like to recoup it, all the MNCs would. That is one aspect. The other aspect is, in India, our people, and in less developing world and developing world, there is a requirement of medical and health empowerment. So these drugs have to be affordable. Now that is the tension. The tension of stultifying incentive to invest these huge sums of money. Because after every 30, 40, 400, 500 drugs they chase, they get only one drug. As opposed to the successful drugs being made available at a price which is affordable. There is also an element of commercial interest because India has some of the leading generics companies, that is, who can do reverse engineering or after the 20-year period is over, pick up that drug, mass produce it, and that many times is a great savior, like it happened for the AIDS drug package, which is a cocktail of drugs which was to be distributed in Africa. Now the Indian generic stepped in. So this is the element of tension. The requirement to maintain incentive for investment, incentive for new drugs, as opposed to medical and health empowerment and the rights of generics to bring about that health empowerment. In India, after the TRIPS regime, there were two amendments, one of 2002 and one of 2005. Now what we did in the Indian Parliament was that defining what is not a patent or what is not an invention negatively, we had section 3. There we had a clause, section 3D, which said in the substantive part that new form and new property of an existing product may not be enough. Because as you all know, after the TRIPS was brought in, as it were, in the Indian Patents Act, you not only had process patent, that is the process by which you manufacture, but a product patent. If you have a new product, that also became patentable for the first time. Now, therefore, it was not enough to have a new form or a new property. You had to show, if you had to get it patented, that it differs significantly with respect of efficacy. Now, that is an expression which is not found elsewhere, and that is, if I may say so, an India-centric provision. There are two other interesting India-centric provisions, one of a slightly more global reach, which is as a part of the sovereign right, because patent is something which is given by the sovereign to a manufacturer. He doesn't have it otherwise. There is no common law right of patent, unlike torts or unlike even trademark, where you are passing off, which is a common law right. In patent, there is no common law right. Therefore, there is a sovereign part of the sovereign, that is the government in a modern democracy, to give patent conditionally. Conditionally means it can say that, all right, you now please make this product available. If you are not using it, I can exercise my right. But what is India-specific or India-centric is chapter 16, which says that there can be compulsory licensing. If, and this is a right given to anybody who can come and say that this patent is not being put to use in India or the price is not reasonable. And the controller can then say that I give you this right. to now compulsorily license your patent. So you're still the patent holder, but you got compulsory licensees whom you wouldn't otherwise perhaps have entered into an agreement with, so that the medical empowerment and health empowerment takes place. Now lastly, there is a teasing issue in pharma patents, and that issue is this. You have what is called a dominating or a basic patent. Now this is classically given by the chip and salt analogy. The Americans are very good at various analogies. This is a very good analogy. So I, supposing, develop a new patent and I create a new product, which is a potato chip. Assume I am the first man who invents it. Let's assume so. So I have a chip. I have a patent on the chip. Now this is the dominating patent. But my friend here, the professor, comes up with a salt. Now that salt is a salt which enhances the taste of my chip, my potato chip. And he gets a patent on it. Now that is what we call an improvement patent. So I got a dominating patent, he's got an improvement patent. Now his problem is that nobody is going to eat the salt by itself. It needs a chip. Therefore, if I don't give him a license with his salt, he'll have to wait out for my balance 20 years and then he will come up with his product. My problem is my chips will sell better if I can use his salt. That is his improvement patent. Normally the way it works out is that we either license to each other or license to a third party. But herein lies the big issue of pharma industry. Now, salt and chip is good. The problem is that most pharma industries, or pharma players, the MNCs, right, try to maximize their profit. Nothing wrong with that. In that process, what they try to do is to keep on patenting all the salts which will go on the chip and then block it. Now that is known as evergreen. That is, you try to evergreen your patent like the evergreen forest, so it never runs dry. And that is the fight which is now happening in India and elsewhere, where you have to use the law in a manner that the legitimate interest of the MNC is protected, but at the same time, the other interests are not lost sight of. And if evergreening classically therefore falls into double patent. I patented A, I patent A again by making it slightly different. Like in cricket parlance, by throwing a dusra. It's the same person, it's the same product, it's the same ball. Therefore, this is the area where in India, partly this was addressed in one of the judgments of La Roche, where I had also appeared and argued as a counsel. But this is the big issue which will dominate the pharma patents for the next several years. The positioning and rights of generics, the positioning and rights of MNCs, and also how this whole issue of evergreening, dominating patents, improvement patents, and when they fall into the abyss of double patenting and therefore are prohibited. Thank you, David.
Thank you, Mr. Tripathi. Now, you have given a broad overview of the concept of formal patent. Well, dealing with that, you have also dealt with the obviousness of the patentee. Now, if it is obvious, there is no patent. So therefore, there has to be something unique. Then only there could be patent. And that is what is the intellect coming in. That is why it is called intellectual property. So, and so far the MNC's interest is concerned, there has to be, you see, so far domestic interest is concerned, that is also to be taken notice of, but at the same time, the multinational companies have to, their interest have to be taken notice of, because otherwise, you see, there will be no improvement so far trade and commerce is concerned. So therefore, there has to be a balancing of both the concept or both the ideas. So with this, I now call upon and request Mr. Robin Jacob, who is a senior manager of Brightleaf India Private Limited, to put forth his views.
Honorable Justice M.K. Sharma, distinguished panel members and my friends. I am here just to give some thoughts about the challenges the Indian trademarks are facing in this review. My discussions will be based on two parts. One is the general issues, and another part is the specific issues. As we all know, India is one of the leading importers of pirated goods, say from DVDs to clothing, from sports goods to construction materials. India, from time to time, has amended its patent, copyright and trademark laws and cited various treaties concerning the IP rights. Since then, India has continued to bring in different laws and regulations to improve the protection of IP, but enforcing the law is proving to be a difficult task. There are several reasons why the enforcement of these laws is difficult in India. The vast size of the country makes it difficult with the limited judicial resource the country has for law enforcement. Local courts are struggling with interpretation and application of ambiguous laws and the necessity for protecting IP rights. Several judges in some of the prominent high courts, such as Delhi, Chennai and Mumbai, are fairly familiar with the trademark law and have been proactively in favor of protection of the IP rights, including the trademarks. However, the majority of the high courts are not manned with persons well versed in IP laws. Judiciary has to be trained under the new IP provisions for the purpose to handle matters of infringement involving technical questions. Likewise, the bar also needs to be strengthened in IPR litigation. At present, all IP matters are being handled by a few law firms. The young lawyers have to take more keen interest in acquiring the necessary skills to conduct IPR prosecution and litigation. This will make the access to justice easier and cheaper for an average IP holder. Secondly, the awareness and respect for IP rights is low amongst the 1 million more Indians. It will require substantial efforts in education to raise the general awareness for IP rights and courts. Such will be a long-term exercise. Now, apart from these major common issues, I will be focusing on the crucial challenges faced by foreign and national investors in protecting their trademarks in India. Despite the risk from infringement of IP rights and piracy, foreign investors with valuable IP rights continue to invest into India as the attraction of the huge consumer market and rapidly developing economy for outweigh the risk. Along with the rapid development of the economy and industry in India, piracy has become more sophisticated and taken on new forms. Instead of direct copying and counterfeiting, a growing number of wrongdoers are adopting the pickpocket approach. The learned players skillfully utilize the existing lacuna in the trademark jurisprudence. Currently, the registration of a company name is governed by the registrar of a company in the region where the company is going to be located. The respective regulations do not specifically prohibit the use of foreign marks as a company name. The pickpocket approach includes first registering a foreign trademark as company name so that the wrongdoer may legitimately use the company name, that is the foreign trademark, on his products or otherwise. And to the vice versa, that is, which is registering the name of foreign company name as a trademark so that the wrongdoer may legitimately use the foreign company name as a trademark. After registering a foreign trademark as a company name, then the wrongdoer may freely use the company name which comprises of the trademark on his stationery, corporate literature, websites, promotional materials and most importantly his products. Needless to say, such use easily results in confusion amongst the consumers in public that the products of the wrongdoers are products of their foreign trademark owner. If the foreign trademark owner files a complaint for trademark infringement, the wrongdoer can raise defenses such as his company name is properly registered, the famous mark has not been used as a trademark on his products. In some cases,